Hello and a warm welcome to Federal's special program, Capital Beat. Civil liberties activist and Supreme Court lawyer Indira Jaising has urged consensus building before the center implements the three criminal laws which are supposed to be implemented from 1st July. Now, 24th of June, the new session starts, and these three criminal laws have to be implemented from 1st July onwards. Now, there are a lot of civil activists who raised a petition. They and Indira Jaising has already written to the Chief Justice of India that there should be consensus building before the laws are implemented. And she's also asked for the postponement of the implementation of these three criminal laws. Now, can this be possible? How do these criminal laws take take on from here on? These are all very, very pertinent questions which everyone is wanting to know because it involves the civil liberties of the citizens of the country. Joining me now is Supreme Court lawyer Mohan Katarki. Thank you so much, Mohan, for joining. And it's a pleasure to have you on the program. And the first question, of course, is that as what Indira Jaising has asked, she's asked for more consensus building before the implementation of these three criminal laws. Do you think that to defer the laws or to defer the implementation, how feasible do you think that would be?
Thank you for inviting me to speak here. The implementation of the law is a prerogative of the Union government under the present three laws enacted by the Parliament. Usually, the laws come into effect on the date the President grants assent. But if there is a provision in a law, a specific provision that it shall come into effect on the date the Indian government or the central government notifies, then it will come into effect on that date. In respect of these three laws, already a notification has been issued by the Indian government that they will come into effect from 1st July 2024. This notification can be revoked, giving a fresh date, or it can be deferred indefinitely. Either can be done, which is fully within the powers of the central government. And this
No, but
power is exercised,
right.
this power is exercised having regard to the circumstances prevailing in the country. Particularly today, we have a circumstance that these three laws were passed by the parliament when opposition members were suspended. Now the new parliament is constituted and the political scenario in the country has definitely changed. Today, it's not the BJP government, it is the NDA government. Therefore, it is a witness of the things that these laws are freshly considered by the Union government and the parliament, and until then, the implementation is deferred.
So, because of the changed political scenario and because of the increased strength of the opposition, do you think that the opposition can put pressure on the government and defer the implementation of these three criminal laws?
There are two things. First is certainly opposition is in a better position to mount pressure on the government to voice for the civil society to communicate their grievances and to communicate the difficulties which the people will face. The most important thing which has been missing in the debate is it's not the just civil rights society which has been asking for protection of civil rights. Generally, difficulties which these laws will create in the implementation, because these laws touch the vital aspects of everybody in day-to-day life. Criminal Procedure Code, IPC, are the vital laws to protect the security of the people. Every day, people are in touch with the courts, are in touch with the police, are in touch with the authorities. Therefore, one doesn't know what is the new law. These laws have been in existence in India, IPC for 150 years, CRPC for the last, new CRPC for the last 51 years. We are acquainted with certain things, procedure, the manner in which it works, the police, judges, and lawyers. Now, all of a sudden, you are going to bring new law. We are not really familiar with that. And until the people are made familiar with that, it's a good ground to postpone the implementation. Whatever may be the objections you have against the laws, we have certainly serious objection that these are the laws which are draconian in nature, which is going to create a police state. But keep aside all those things, purely from the point of the convenience of the people, the inconvenience which it is going to cause, and the difficulties, these laws must be, implementation must be postponed.
But Indira Jaising has also pointed out at a thing that this would increase the backlog of the cases. The judicial system is not really abreast to handle these laws. There is not enough and sufficient training of the people. Uh, Now, do you think that all this should be postponed because of these problems? And these are logistical problems. That if the manpower is not trained, if the judicial system is not well equipped to handle these three new criminal laws, so we might as well just postpone it. So can this become the most powerful ground on which one can seek the deferment?
Yeah, I fully agree. This is one of the most important ground because so far there is no audit from the judiciary to understand the impact of these laws. Prima facie, it appears these laws are going to increase 30% litigation, that is criminal litigation in the High Court and the Supreme Court, because every provision which has been reworded, reenacted, calls for a fresh interpretation. The decisions of the Supreme Court or the High Court in the last 150 years, which includes earlier pre-council, are of no value because these decisions do not apply to the new law until the Supreme Court says this decision, which was in which the so and so provision of the old laws interpreted, applies to the new law also. Until then, there is no authority. Therefore, it is going to increase the litigation to large extent because most of the provisions, for no reasons, have been reworded, either a grammatical correction or this or that. In fact, I must tell you that in the name of grammatical correction, you have made grammar much worse now. That's what the general feeling of everyone. So these laws are not really intended to promote any decolonization or anything. These are the laws which freshly recodify the English common law and nothing else. And in the process of recodification, we have reworded so many provisions, and all these provisions will have to be freshly interpreted by the Supreme Court as the case comes, and that takes decades and decades. Therefore, this is all going to create a legal torture to the people. In the fitness of the things, I would always appeal to the parliament to repeal these laws. But whatever technological advancement you want to bring into the criminal procedure, whatever you want to redefine the IPC, please bring that by amendment to the existing laws. There is no need to overhaul the whole structure and unnecessarily put the court into trouble by the process of reinterpretation. Therefore, she is right, Indira Jaising, that it is going to increase the criminal litigation by 30% and add to the existing huge backlog lying in High Court and Supreme Court.
But Mr. Katarki, what do you think are the most dangerous provisions, which really impact the civil liberties, and will these laws really end up in hollowing the democracy?
Yeah. Say the Criminal Procedure Code is intended to reduce the powers of the police, high-handedness of the police, and protect the liberty of a citizen. That's why the regulation comes. The common law powers of the police to arrest, to detain, to extract statement, all these things are regulated by the Criminal Procedure Code. When you decided to reenact these laws in a different form, who has decided? It's not the Ministry of Law. It's not the Law Commission, which is headed by a former judge usually. Laws are redrafted by the Law Commission based upon the experience, based upon the recommendations made by the suggestions made by the judiciary in various judgments. But this has been done by the Department of Home or Ministry of Home, which is nothing but a police department. Now, through a hand-picked committee, I'm not questioning the credibility, I'm not questioning the competence of the members of the committee. But all said and done, it is a committee constituted by the Ministry of Home Affairs. So, prima facie, there is a suspicion that it is intended to increase the powers of the police and therefore enact a police state in India. From this point, the laws have to be reviewed. Now, if you ask me specifically what are those provisions which increase the powers of the police, which will denude the rights of the individuals, the foremost is the period of detention. The police custody under the existing law is 15 days. But in this law, the new law, it can extend to 60 or 90 days in case of some serious offenses. So this is something which cannot be tolerated by civil society at any cost. Secondly, you have enabled the police to attach the property without taking the permission of the magistrate. The beauty of the Criminal Procedure Code is, in order to protect the liberties of the citizen, the police activities are continuously monitored and supervised by the judiciary, that is, judicial magistrate. Now, this requirement, if it is dispensed with, it is only intended to increase the powers of the police and nothing else. So these kind of things give rise to a suspicion that you are intending to enact a police state. Another important aspect is the sedition law. Section 124A, the government claims were deleted, but what you have deleted? Nothing. You are reenacted in section 152 of the BNS, and the wordings of one section 152 of the BNS are so vague. It will give more powers to the police to arrest a person who is expressing his political ideas. Uh, by just saying that whatever you are talking affects the sovereignty of the country, police can arrest the person and put him inside and can demand a police custody for 90 days. So this is, on the face of it, is draconian. And if you look to the experience, what happened when 124 was there, which was better worded, even then it was used in a draconian manner. This 152 is going to be definitely used in draconian manner, and judiciary will be helpless because the law says police custody up to 90 days is permissible.
But Mr. Katarki, I was just looking at the article of Indira Jaising very carefully, and also when we were discussing that even after the repeal of the existing laws, these laws would continue to operate for offences committed till the end of June 2024. So, are we going to see like two sets of criminal laws for a long time to come?
Yeah, this is true in respect of the Indian Penal Code. The offences committed till the date the new law is implemented, now take it 1st of July, till then any offences committed will have to be tried under the existing law, that is Indian Penal Code. The case which starts before 1st of July will take 20 years in India to end after trial and appellate decision and all. For the next 20, 25 years, you are going to still be dominated by the existing laws. With regard to the offences committed after 1st July, new laws will apply. They will come up for trial something after 10 years, and appellate court will deal after 20 years. It takes time. So during the period of next 25 to 30 years, we'll have two set of laws. One is Indian Penal Code, CRPC, as now exists, and the BNS and BNSS, or so the Evidence Act, as the Parliament has now enacted and which has been enforced, which will be enforced. So this is going to create a lot of chaos and add to only the existing legal troubles.
Right. So if it is going to increase the chaos, it is going to increase the legal troubles. It's not going to help the citizens either. What has the government achieved by implementing these three criminal laws? Just by saying that no, we are trying to decolonize the laws. How would the people take it? And will it now be challenged in the court? These three laws can be challenged in the court, the constitutional provision especially.
If I can say the least, when somebody says these laws are intended to decolonize, I feel like laughing. What is decolonization? This is completely English law which has been recodified or freshly codified. Is there anything Indian in this? Is there anything Bharatiyata in this? Nothing, except the titles which have been put in Sanskrit, which is again a wrong thing because you cannot put Sanskrit title or some other title in English. English has to be read in English. You cannot teach English literature in Hindi, okay, or Hindi literature in English. So this is something ridiculous, but this is what they have done. But going to the question, decolonization, I do not see single word which promotes Bharatiyata or Indianness, nothing as such. All that the new law does is to recolonize India by giving more powers to the police and nothing else.
But what is the government achieving at the end of the day? What do you think is the intent of the government? No matter what they say about decolonizing this, that, you explained that very well. But what is the political messaging behind the three, bringing in the three criminal laws?
This is just empowering the police and giving more powers. That's all. I don't see anything, any purpose behind it. And the very fact that it originated from the Ministry of Home, that shows this was originated at the instance of the police and intended to empower the police. If police have any specific issues to be
So,
addressed, that is a separate matter.
right, but Mr. Katarki, empowering the police, and then trying to curb the dissent, trying to repress the opposition, is that what you see happening then in the coming days?
And of course, it is already happening. It is going to happen in a bigger way the day these laws are implemented.
But when these laws, were passed in Parliament, we still remember that a lot of MPs were suspended at that time, from Lok Sabha and Rajya Sabha. Now, in that situation, the laws were passed. It was made into an act, and now uh, it's like a cycle. Now, the same government has come back, but with a lesser mandate, and it's a coalition government where the opposition is almost on an equal footing. So, what can the opposition do? What are the options left with the opposition?
Well, the parliament should first reconsider, government should introduce a bill uh, and reconsider the matter by referring it to the select committee. The select committee should look into the matter threadbare and decide whether first we should replace or we should only amend the existing laws. I would propose very strongly, and I'm sure the new parliament will consider in its wisdom, the amendment of the existing laws to accommodate all the necessary or important technological changes which have been proposed in the laws, these new laws, and that should serve the purpose. So once that is done, this trauma of seeing the new laws unnecessarily replacing the existing laws and burdening the judiciary with 20-30% of more litigation will end.
A lot of civil society groups have started raising a petition, and they are writing letters to Chandrababu Naidu now that he's an important coalition partner of BJP. They're writing letters to him that it's up to him how he can protect the integrity and protect the civil liberties of the people. Try and just postpone the implementation of the laws. Do you think that a step like this can really make a difference?
Yeah, in a political sense, it makes a difference. People have a right to appeal to the politicians. People have a right to appeal to members of parliament. Chandrababu Naidu represents a political party with 16 members of parliament. And in a house of 273 being the mark of majority, this present BJP government has only 240, which is short of 33 members of parliament. So Chandrababu Naidu and Nitish Kumar hold the key. If they are convinced, certainly they can convince their partner BJP to repeal these three laws and freshly consider the matter in the parliament by introducing new laws and have them referred to the select committee. And after that, whatever passes through should be acceptable to the people.
But what happens, Mr. Katarki, if the government goes ahead with the implementation of the law, or do you see some kind of a public movement, people coming out on the street, like what we saw during the farmers' bills when they were passed? Uh, what are we what are we expecting, or do you really you see this entire matter being reconsidered, or as what you suggested, where it should be referred to a select committee? What is a higher probability?
See, unlike farm laws, these laws do not directly affect the public. They indirectly affect larger section of people, no doubt. Therefore, there cannot be any mass movement against these laws, but people will suffer. And then it is for the judiciary to consider what to do about it. But once the laws are implemented, it will be very difficult for the judiciary to stay and then allow the old law to prevail over. Anything of that kind has to happen before the end of June. It cannot happen after the laws are implemented, that is 1st of July. So I don't see at the moment anything happening like that. It happens great, but at the moment I don't see anything.
Okay, thank you, sir. Thank you so much for joining on the Federal. And one appeal to the viewers who are watching this interview: subscribe to our channel, send us your feedback, and stay tuned to the Federal. Thank you.